knows what's good.
Yes, that can be enough of an intro, I guess. So with us from Mauer is Jessica Eaglin, who has come over and is writing about the counter-narrative of technology. Virginia Eubanks has joined us, and for those of you who are readers, you will know she wrote Automating Inequality, which was one of my summer reads. Recommended by a lot of people. It's on a lot of lists of books you should read.
Boom.
I almost brought mine in. Mine's not. Mine's a little road weary.
Wow.
And then we're so you know.
Also love her book.
Mine's proudly sitting there because I made my husband read it as well. Because he does techie stuff. And then we're also doing a road show for those of you who are live streaming across. We will be over at 3 o'clock at the Mauer School to reinitiate this conversation and go in a slightly different direction. But today we're here to talk about Jessica's paper. She gets 5 to 7 minutes, and I'm cutting her off like a good academic who should be moderating this panel. And then Professor Eubanks is going to ask the first couple questions to get us going, and then we'll go from there. So off we go.
All right.
I'm going to pull up your paper.
Great. Well, thank you so much. It is a pleasure to be here today. So thank you to Angie for making this happen, and thank you to Virginia for being here. I am really honored to be in such great company. All right, so I took the suggestion quite seriously to only talk for 5 minutes or so. I'm going to do my best. I assume that everybody has read the paper, so I won't spend too much time recapping that. I'd rather just talk a little bit about how I came to this project. So I write about sentencing reforms that have been adopted in the United States to respond to the economic and social pressures of mass incarceration. And as you saw from the article, this term mass incarceration has actually taken on a number of different meanings. So the traditional term refers to the exponential increase in the size of the United States prison population since the 1970s, to the point today where we have somewhere around 2.2 million individuals that are behind bars. And it secondarily refers to the disproportionate impact that the increase in incarceration has had specifically on minority populations, African American men in particular. So that the incarceration rate has disproportionately impacted black men. And so as the size of the incarcerated population has increased, the impact that the criminal justice system has had on particularly poor communities of color from urban centers has increased as well. And so the question that really drives much of my research is now as states are, in particular, and I focus on the states, but as states are trying to address, usually motivated by economic pressures, they're now trying to address these sort of the realities of mass incarceration. Are they actually addressing the disproportionate impact that that the criminal justice system has had on minority populations? And will the reforms that they're adopting actually decrease the size of the carceral state? Or are they doing something else? And so that's how I got to this place of considering risk assessment tools at sentencing. They are very popular. We were just referencing that. They're very popular as sort of a pragmatic reform to address the pressures of mass incarceration by identifying individuals who are most likely to succeed if diverted from incarceration. Ideally, they would be diverted to some other alternative at the sentencing stage. That would allow some sort of government surveillance, usually something like probation terms or something of that type. But they are not, they're identified as people who don't need incarceration. Anyway, and so this paper tries to connect the sort of history of sentencing technologies with the rise of risk assessment tools. And so I talk about the creation of parole guidelines in the 1970s, sentencing guidelines that were very popular in the 1980s and were designed to constrain judicial discretion through sort of the creation of these big, in the federal system, something like 235-page rubrics that tell judges what sort of factors they should be concerned about and what particular outcomes should occur in the average case, in sort of the heartland of cases. And I connect that to the 1960s and the rise of risk assessment tools in clinical rehabilitation, which is often considered sort of the glory time of criminal justice, right before mass incarceration and the rise of our prison population in the 1970s. And so this paper kind of critiques the rise of risk assessment tools and says, look, the basic thesis is that, you know, these tools were created to avoid these larger sociological sort of concerns that were arising at the same time that the tools were being implemented in criminal justice. And we are at this stage now where we aren't even thinking about sort of the social aspect of why we're introducing risk assessment tools. And I suggest that the reason that it is happening, at least part of it, is because a lot of our concepts that inform what we think is sort of punishment, what does punishment mean in society, have changed through the introduction of these technologies. And so I talk about rehabilitation and sort of racial equality in sentencing and the idea of dangerousness and its distinctions from this concept of risk to sort of undermine or at least to complicate this broader narrative that risk assessment tools, even if somewhat problematic, are a positive step in sort of improving judicial decision making at sentencing. And I will stop there.
Thank you. Perfect timing.
So I so appreciate the opportunity to engage with this paper. It's really, really useful, really clarifying for me around some things that I think are common across criminal justice and other agencies that are using similar statistical decision-making tools like welfare, public assistance, child welfare, homelessness, the other kinds of things that I write about in automating inequality. So it's really interesting for me to keep an eye on the patterns and the places that there are distinctions and differences. So it's been really fascinating for me to engage with the paper. So I appreciate the chance to read it. And one of the things I really appreciate about your work is this focus on narrative, right? This idea that these technologies tell political stories. And in automating inequality, one of the things I say is, ironically, one solution for bad data systems may be telling better stories. So I want you to take a minute to tell us why you think it's important to sort of re-narrativize these supposedly objective apolitical tools. And to be very clear, like one of the most popular blogs in government technology is literally called Apolitical. And so there's a story here we're telling about these tools that I think your paper sheds some light on. And so I want to give you a chance to talk a little bit about that, about why narrative matters.
Should I take that up right now? Okay, awesome. Yeah, so I think I touch on that in the paper. It's something that I want to sort of tease out more, and all of my papers sort of get at this question of narrative. I have a humanities background, so I was I got my master's in lit theory at the same time that I got my JD, and what has fascinated me as I have gone into sort of the legal scholarship realm is that the humanities are very subordinated, and the idea is that if we can push against sort of existing problematic sort of realities, particularly that relate in this context to punishment in society, but the way to do that is through empirical data. And I don't think that there's anything wrong with that, but I think it tells a very incomplete story, and this paper very much is writing into that space where, the response that I got, so I've written one or two pieces on risk assessment tools and sort of issues of construction and governance, political governance in other contexts. But what really drove me to this paper was the response I got in other papers, which said, well, you criticize risk assessment tools for including all these factors that are very clearly proxies for marginalized communities, African Americans in particular. I mean, risk assessment tools include, factors that are, first they start with gender, right? So there you go. But then they also include criminal history, and we know that criminal history is disproportionately, particularly things like age of first arrest, like those are very sociological factors, right? Like if you live in a community that is highly surveyed, by the police, you are that much more likely to receive some sort of criminal record of some type earlier on. And so if that's how we're going to predict risk, we're actually telling a very different story, right? Risk assessment tools are telling us something other than that these are the people who are most likely to commit some type of crime again in the future, but we don't sort of engage with them in that way. Anyway, but what interests me is that the comments that I got in response to this critique was, well, but this makes the tools more accurate. And if the tools are more accurate, they're going to do, or they're going to facilitate something that is very good, which is rehabilitation. And wasn't the problem when we moved away from when we started, this massive increase in the size of our prison population, wasn't the problem that we eliminated rehabilitation as sort of our guiding purpose of punishment? And so that really fascinated me, because when I look at the tools, and I see this expansion of government surveillance, it might be a more benign version of surveillance than putting somebody in prison, but that's not necessarily, it certainly isn't freedom, and it certainly isn't addressing what drives people into the criminal justice system in the first place. Anyway, and so the response that I got was, this is rehabilitation. This is addressing racial bias. And this is a way to identify the people who are most dangerous in our communities. And I said, well, how did we get to that point, right, where we just accept that story, that this is what rehabilitation was? And I've written an entire paper in the past that said this is not what rehabilitation was. So this paper sort of, references that a lot, but I say this is a new kind of rehabilitation. And why are we comfortable with that? And I think that that's really driven by the narrative, not as much by the reality, right? So we are shaped, and I have a point in the paper where I sort of talk about, one of the concerns is that in response to mass incarceration, we are forced into using risk assessment tools. Like, this is the only way, or this is the best way to address this social problem. And what I suggest in the paper is, no, we make decisions about what is the best or the right solution for us based on our sort of social understandings of society and punishment, and then we implement that in a way that addresses what we consider this problem. So the economic pressures of mass incarceration might sort of trigger a motivation to address mass incarceration, but the way we choose to do that has everything to do with these social concepts of what punishment is and what punishment is not. And I think that that's all about the way we sell it, right? And there's no way to sort of undermine the expansion of the carceral state if we don't sort of undermine the narrative that people just accept without sort of critical reflection. And that empirical data on its own is not going to be enough to undermine that narrative, right? It's so strong, it's so pervasive, and it's rhetoric, right? And if we don't start attacking rhetoric for what it is, we're only fighting, we're fighting like with one arm tied behind our back.
So you mentioned this just in passing, but I want to give you a chance to sort of dig at it a little bit, because I want to talk about one of these narrative shifts, and this shift is specifically around sort of the ascendance of accuracy as the primary, if not the sole value at sentencing. So this can be, I think, counterintuitive for folks, so I want to give you a chance to respond. And just by asking, like, isn't accuracy good? Isn't it the same thing as the correct decision? Like, is there a difference between accuracy and the correct decision? And then I have some more to say about that, but I want to give you a chance to respond first.
So this is picking up on a conversation that we had last night, and I went to a conference. I get this a lot. People have come up to me and they say, "It sounds like you're anti-accuracy, as if it is scandalous." And I'm I've come to this place where I'm like, yeah, accuracy, technical accuracy, is not the only value that we pursue at sentencing. And so a technically accurate tool could, it could measure what it says it's going to measure without actually giving us some new insight to our political values, which inform what we think is a proper sentence or what the proper considerations are at sentencing. And I sort of tease it out in this paper, and I certainly have done it in another paper as well, where I sort of talk about, there was a point where we rely on risk at sentencing for a long time. We have basically since the 1970s. But it was a sort of a socio-political decision to rely on risk through criminal history, something that we felt that people felt was something that individuals choose to acquire, at least in some way, as opposed to including these factors that now make the tools more accurate. So gender, like neighborhood, we've talked about that. All these different factors that really go to something very different, right, than the criminal history. And I think there are scholars who have critiqued sort of the reliance on risk through criminal history, and it's created this sort of divergent narrative where the concern is that criminal history is not accurate. It's not as technically accurate as these risk assessment tools, and so the tools must be better. And then there's this other argument, and that's what I'm sort of writing into, to say, like, there are all these reasons why we only used criminal history. And so the takeaway, and the takeaway could be, the problem is that we're relying on risk too much. But we don't look at it that way. Instead, we say the problem is that our assessment of risk is not technically accurate. And so, so I guess I'd say, accuracy is a narrative, and it's only one because it is feeding into a particular set of values, efficiency, being the primary among them, that by having a more technically accurate tool, we can have a more, efficient criminal justice system. That is only one value that we pursue in criminal justice and at sentencing in particular. And there are others, right? Equality is one, and that has sort of moved in the direction of technical accuracy as well, where you've got a lot of literature that's saying, let's define equality according to technical accuracy instead of according to sort of the sociological realities of what these factors might reflect in society. So, saying why do minorities have larger or are more likely to have criminal records, and what does that say? And instead they're saying, well, we can make a technically accurate tool by tinkering with this feature of the tool to make it consistent in every circumstance, but that has no context to it, right? And so I guess the concern is that accuracy itself is a contextual question, and I've written elsewhere to say that technical accuracy measures on all these things that sentencing we have accepted for a long time doesn't necessarily.
So I also want to open it up for questions. So.
Can I ask one follow-up before we let it go to the floor? Sorry, I'm just gonna abuse my privilege as sitting at the front.
You can.
So there's sort of a related argument, which is many designers that I spoke to said get kind of eye-rolly when you talk about the over-surveillance of high-risk folks, because they'll say, look, really what these tools are doing is keeping low-risk folks from interacting with the system that they shouldn't have to interact with. So this came up for me in the child welfare system, but I imagine it comes up in criminal justice as well. So how do you respond to this question, or this idea that these tools are saving low-risk folks from interacting with systems that have really profound impacts on their lives? Isn't that a good thing? Isn't less incarceration a good thing? Isn't fewer child protective services investigations a good thing, even from an abolition standpoint?
Mm-hmm. Yes, I also get this all the time. Okay, so the first question is, are the risk assessment tools actually identifying people who are a threat to society or a threat to communities? And that is actually an outstanding question, right? So the tools are good at identifying people who will re-enter the system. But people who re-enter the system include individuals who are over-surveyed, right? So individuals, and I have written about this elsewhere as well, but individuals who are put onto probation or parole in some instances, but usually it's some type of probation, have all these additional conditions that when you as I tell my students, when we go through some of these conditions, they're like, I could never live up to that, right? Like, you have to go, you have to do drug tests every single week. That doesn't sound that hard, but, it is hard when you say, this includes, not drinking alcohol. This includes all these things that people use every day. This means checking in with your probation officer every week, sometimes every day, through a phone call, through some sort of portal, which are now very popular in certain communities, and that keeps you from being at your job from 9 to 5. And the people who actually have jobs from, the people who are most likely to find themselves in the criminal justice system are the people that have these 9 to 5 jobs and don't have the privilege of saying, I'm not coming in until noon today, see you tomorrow, right? Like it's the accumulation of all these different types of surveillance that often are reflected in the risk assessment tools themselves, right? So they can say, if this person's coming back, this person might be coming back because they're already they're more likely to fail. And the tools don't account for that. So part of the answer is, the people that they identify as high risk aren't the kind of people that we actually are concerned about. And then I've written elsewhere to say, it actually also doesn't identify or doesn't facilitate, and this isn't really about the tools, it's more about sort of like the frameworks that we build around the tools, the diversion of the people who actually are low risk in all circumstances. So there's a bunch of people who are low risk of recidivating, however you want to define that, but that we won't divert, right? And the great example here is that, in the context, it sounds sort of out there, but in the context of murder convictions, these are the people they have some of the lowest rates of recidivism. And they have been, at the same time that states have been rolling out risk assessment tools, they've also been rolling out provisions, statutory provisions that prevent the consideration of certain types of serious offenders who had been convicted of serious offenses from any, sort of opportunity for release. So to the extent that the narrative is that you are preventing the diversion of the low-risk individuals while ensuring public safety through, sort of identification of high-risk individuals. In implementation, there's all these political sort of things that prevent that from happening. And then also, to the extent that we say we are, identifying individuals to divert them from terms of incarceration, what they end up getting instead are often onerous surveillance requirements, right? To say, like, this person is low risk, and so we are going to put them on all of these different, sort of minor surveillance provisions, the same ones that lead to people recidivating, right, to entering and staying in the carceral state. And there's really no engagement with that either. So you say, well, yes, if in theory we were actually diverting people from the criminal justice system and preventing them from coming back into the system, then maybe these tools will be doing something good, but that's not actually how they're being implemented at all. And that's not exactly what they're testing for, right? What they're exactly measuring. And what I find, and I would love to hear what you think, but what I find is that people then say, well, that's a problem with the humans. That's not a problem with the tool. And and my response is, no, that's a problem with the tool and the humans, right? And it's not necessarily the humans in the sense that judges are reading the tools wrong, but it's the humans in the sense that we think this is a depoliticized solution and that we don't have any sort of obligation to address the actual social problems that facilitate and maintain our extensive reliance on the carceral state.
Thank you so much.
Questions? Yeah, go for it. Introduce yourself.
I had her seminar in literal sentencing, so.
Oh,
So she's heard it all. She's heard it all before. I'm looking at her and she's just like, yeah.
I went to another insight. Okay.
No, I love the focus on language and rhetoric, and I had just a couple comments. There's this David Krakauer at the Santa Fe Institute in Information Sciences. He talks about cognitive artifacts. And there's two types: the complementary and the competitive. How things like calculators replace our ability to do math, and things like maps or language are complementary. And it seems like this is maybe a good frame for the use of these tools, since replacing our capacity for judgment by conflating like standardization or neutral application with fairness in some way. And the second one was whether there's some sort of hermeneutics like issue with selection of variables for the data that's used. And I feel like those two things could maybe supplement the rhetorical component, which I really liked.
So it's really interesting, and I am not familiar with David Krakau's work, but I will definitely look at it. And I think it's a great analogy, right, to say, suddenly you go to the grocery store and, you're talking to, like, the woman that's checking you out or whatever, and she says, how much change do you need? And everybody's just standing there staring at each other, waiting for the register to run, right? And it's like, you go with your parents or something, and they're like, obviously it's this. You say, man, I feel very slow, and I swear I was in those classes, but if we don't exercise those skills, we will lose them. I only allude to it here, but I am very concerned about that in the context of judges. And it's something that fascinates me and concerns me at the same time is that judges will get to a place where they don't think that they can actually sentence without the tools. And what fascinates me in this context, and Sam knows a lot about sentencing guidelines because she was in my class. But what fascinates me about this context is that when the sentencing guidelines were rolled out in the 1980s, judges said, I don't need it. I know how to sentence, and I don't need some sort of, technological framework to give me an answer to what this person deserves. Now, I'm totally willing to say that judges can get it wrong sometimes, but what interests me is now in the context of risk assessment tools, judges have been some of the largest proponents of risk assessments. So whereas in the 1980s they said, I can do this without a tool, now they are concerned, and some of it is political, where they say, this will give me cover to do maybe what I always wanted to do, but also that they feel like, I need this. I don't know what a tool, that I know a tool could do better at assessing risk, and that risk as defined by a tool is what risk as what I care about at sentencing, that these must be the same thing. And there's no distinction between that. And so I think that, that is literally, it's the same thing as watching a bunch of people staring at a register at a grocery store, where it's like, you used to know how to do this. And older judges who are now retiring still say, I know how to do this. But newer judges don't. They say, I want the tools. And what does that mean as we head in this direction, which I see very, right around the corner towards AI judging, right? Where you can say, developers are going to say, we don't even need judges, because we can predict exactly what an average judge would say in a particular circumstance. And now what we've lost along the way, we've lost so many things along the way, but one of the things we've lost is that social context, right? And we talked about this a bit yesterday, but judges are some of the only people who actually interact with defendants in the criminal justice system, right? These are the people who actually have to sit there and listen to those defendants say, this is what my life looks like. And this is how I got to this point. And if we start cutting them out of sort of our definition of what is included in justice, we're losing a lot. And so, yeah, and I'm going to pass on the hermeneutics of the variables question because I wrote a paper about it. And I actually still don't like that paper, so I'm just going to pass.
Can I offer just a very quick reflection? Yeah. Do you mind? So I think one of the things, and it comes back to how important it is that you draw history into these tools, and I'd love for us to talk about that if we have time. But I think one of the things that's really important is the integration of these tools tends to be part of a larger process. And the process has everything to do with shifting what these jobs mean. Right? So in the welfare context and in the child welfare context, how the process played out is in usually the 60s and early 70s, and it's important to locate it in that moment in time because there's very important things happening at that moment in time. There was this shift to these clinical tools, actuarial assessment tools. Part of what happened as those tools rose to ascendance is they redefined what these jobs were. Yeah. They said, actually, your job is not care work. It's not dealing with trauma. It's not finding justice. Your job is managing information. Right. And then once you have convinced people that their job is managing information, then actually it's very easy to automate the processes because you said, like, okay, caseworkers, all you do is make sure that the tally is correct. If all you're doing is tallying correctly, right, then a computer can do that better than you. And they're right, a computer tallies better than human beings tally. But the reality is, the older caseworkers I talked to, I made sure to talk to people who've been around for 30 years or 35 years, they would say that's not the job though.
Yeah.
Like the job is sitting with people in their trauma and helping them see that things can get better. And that's something a computer can't do, but if you've allowed the tools to shape what the job is, then you then have no argument that the computer doesn't actually do this better. Because the computer does count better than caseworkers or judges, right?
Yeah, and I just add to that, I mean, we've talked about this. It's so interesting in the context of sentencing because unlike in the context of caseworkers in sort of the welfare context, where these are individuals who often are, not that different from the people that they are trying to offer care to. In the sentencing context, these are high profile, well educated, sort of last line of defense, well-esteemed individuals in the criminal justice system. I mean, these are judges. And so it makes it all the more and yet all the less notable because it's the same thing that's happening in other contexts. So you change what the job is, you change what sentencing is, and you suddenly make it into a very managerial kind of profession, right? The sentencing component anyways. That's not to say that judges don't have very specialized, expertise that they use all the time. But in the sentencing context, you push it slowly in the direction of sort of management. And when you do that, it's really easy to replace them. And now I see us as prime for a, innovation. And in the law and tech context, you see people writing about it all the time. But in a few years, I'm sure that we will see very serious suggestions that, this is a great way to save money would be to just stop making judges do sentencing. And that's because of something that happened 40 years ago, and the way that we are shifting over time to accommodate that shift, which I think is facilitated, is sustained by a narrative that this is better. And it is just a narrative, right? There's a lot of reasons to think that that's not the case because those weren't the jobs.
So thanks for this paper. This is way outside of my lane, so I'm a little reluctant to ask a question about this topic. But it seems the paper talks about these tools that maybe make bad decisions or have bad outcomes. But you talk about there's a lot of states that use these. 17 require them, and maybe even more use them. So taking a step back, are there any of these that are actually better than others, or are they just all in the same category as bad? And then a kind of a related question is, have some of these involved in a way that actually makes them better? So are they all bad, or are there some designs that are actually okay that we can maybe learn from? Mm-hmm. And then who's actually making these? If these are private prisons that are programming these things, obviously bad. But if they're a bunch of people from law schools or something like that, could they be okay? So I'm just wondering under what conditions might they actually be good?
Okay. So great questions. Are these all bad? There are, that's a really loaded question because it depends on what you think makes them bad. So some people would say, there are a lot of tools in use right now and they could be better because they could be more technically accurate. At the end of my paper, I suggest that there are some states where they have said, here are all our other values, and these risk assessment tools don't violate those, right? So these risk assessment tools rely on criminal history. They don't rely on gender. They don't rely on geographic neighborhoods. They don't rely on these things that are proxies for other sort of social inequalities. To me, I would say that's a lot better. Now that's contradictory to sort of the technological narrative, right? Which would say, basically I think that the tools that are not as accurate are better because they make a lot more sense in sentencing. And so it's reflecting this deeper question of what you think makes them better. But you've got a lot of both. Like you've got some states that are moving in the direction of adopting more technically accurate risk assessment tools, and you have some states that are still saying, these risk assessment tools don't fit our sentencing infrastructure, our sentencing policy values. Who are making the tools? And let me emphasize, before I move on to that question, let me emphasize that I specifically am talking about sentencing. So what are the tools that get before a judge? Because when you get to the question of what kind of tools are being used by probation officers, parole officers, which can, in a broader context, also can include sentencing, of course. They are using much more technically and statistically robust risk assessment tools. I'm looking at Angie because she knows, because she's one of the people that made them. So, which leads to your next question. So who are making tools? It's interesting because, and this goes to sort of why I talk a lot about rehabilitation. Some of the leading scholars that have developed these risk assessment tools are actually rehabilitation scholars. And when I say that, these are like unicorns in the world. Like, people abandoned rehabilitation in the 1970s and did not look back. And there were a small subset of scholars who said, no, rehabilitation was a good thing, right? It was a good thing. It was a good value. It was a good purpose of punishment. And it was something that worked. And we were going to set out to empirically demonstrate that it does work. And so now the tools are being developed by publicly and privately, owned companies, just as much as they're being developed by sentencing commissions, government commissions of some sort, and they all cite to the rehabilitation scholars. So to the people who were actually genuinely trying to improve, to try and sort of write against this turn towards the punitive in the 1970s and 1980s. But again, in the process, they wrote out half of what rehabilitation was. So rehabilitation was about reintegration into the community, and not through surveillance, right? It was through sort of getting people prepared to get jobs, getting people, connected with services that they needed. And in the process, they developed these risk assessment tools, and those tools have now been used to facilitate an increase in surveillance mechanisms. And so it's, there is an argument, and I have engaged with it in other work, there is an argument that what we really are concerned about is that the risk assessment tools are being developed by privately owned companies. There are a lot of problems with the fact that they're being developed by privately owned companies. I mean, they're not transparent, which is, at least in theory, part of the reason why we are adopting the tool. So they're not even doing what we say is sort of like their, value add. They have a lot of incentives to use the kind of data that is easiest to access, which is not necessarily reflective of the communities that they're being used in. It's not necessarily reflective of, again, the criminal justice values. So, use arrest data. They can use information that has been, otherwise overturned, that's going to sort of change the outcomes or sort of change its appropriateness for different states depending on their sentencing laws. I think all of that is really problematic. But that's not the only problem. So it would be sort of disingenuous to suggest that the problem here is that individuals are coming in and trying to make money off of, the creation of risk assessment tools when they are also being developed by publicly owned, institutions or companies. A lot of universities have done. So University of Cincinnati does a lot of work on developing risk assessment tools. Like, University of Cincinnati is like the haven of rehabilitation scholars, and they've developed a tool that's used in Ohio, and it's totally transparent. And that doesn't mean it doesn't have the other issues that any tool that would be implemented by a private company does.
Yeah. So I guess what concerns me to some extent is, do we have to be? Are we throwing the baby out with the bathwater? Mm-hmm. And ideally, what we'd like is a panel for the last 40 years mm-hmm. across all states and over time, so that we could judge outcomes. Because at the end, we've got right now anecdotes where we've got North Carolina, mm-hmm. and they say, "Oh no, we're not using this anymore." And you talk about that at the end, or Justice Stevens saying, "No," mm-hmm. And those are really good, but how are we to judge the outcomes? Because we're going to make errors, type 1 and type 2 errors all the time. So, do you have, if we gave you $20 million and you were going to go off and do this project, how would you try to determine the downstream outcomes of those states that used it or those states that used it supplemented with something else. And I think it's it's part of a broader range, and Angie's conference on smart cities got me thinking about these issues too. But I was talking to an experienced pilot, and he was saying, you really don't want to be in a plane when all hell's breaking loose with a young pilot, because all they can do is look at the screen and the technical stuff. They don't feel the guts of the plane. They're not trained that way. And so it sort of reminds me of what you're saying about these judges. And so now that we've got these, so we're stuck with young judges, right? So then, given that, how do we use these tools in the best way or not? And so, there's some normative aspects in here, but what I'm pushing you on is to really make the case in front of somebody. We'd want a positive argument as to look at North Carolina now. Their outcomes are a lot better than, I don't know what other state, Illinois or someplace. So have you thought about how you do that kind of research design? I mean, that'd be a huge, huge thing. But even if you took, your 5 best states, your 5 worst states, or the middle ones, how would you think about doing that?
Yeah, so it's a really complicated question, and there's some really interesting empirically driven research that tries to parse out, what are the best sort of guideline states, what are sort of the legal frameworks around the tools that are sort of the most most positive or most effective. Certainly in the context of the guidelines, not the risk assessment tools, although there's like a mirror conversation happening. There was this sort of divide between whether states should have mandatory guidelines to say, like, here's what the framework says and you have to do it unless you can defend, against, like, you have to have an articulable reason why you are not sentencing within this range. That's actually what we did in the federal system, and it was just criticized. I mean, just criticized. Like, everybody said the federal system was bad. And most of the states actually did not have quite as mandatory or quite as sort of like detail-oriented sort of guidelines. And so there's a lot of research that sort of asks that question, like, what way of designing the guidelines is the most effective? And I think you can see there's a start of that kind of empirical research. There's a guy at Duke who I admire very much, who's doing that research in Virginia, because Virginia is one of the first states is the first state really to roll out risk assessment tools at sentencing, and sort of asking this question of, did it actually make the tool, or did it make the sentencing outcomes better? Of course, Virginia's prison population did not decline when they introduced the tools, but potentially it would have staved off a rather large increase that might have happened otherwise. I think that, so I want to recognize it's a really important question. My project isn't really asking that empirical question, right? My project is more saying, I think that stuff is important, but we could have all the empirical data in the world that would tell you that these risk assessment tools, like this model didn't work or this model did work better, and we still wouldn't be able to actually fully engage with whether the tools are sort of a net sum, like, improvement at sentencing or not, because we aren't taking account of the ways that those tools have subtly changed the way that we think what we're supposed to be doing, or that we think of or conceptualize, as Virginia sort of suggested, what the jobs are that people are supposed to be doing. So there's a scholar at Chicago who says, basically, like, all the studies that have come out that say risk assessment or that sentencing guidelines improve sentencing have really demonstrated that the judges are better at doing what the guidelines told you to do. It's not necessarily telling you that that's a net improvement on sentencing. And so then the question is, so that gets to this question, your first question, and then the second point that you made, I think, is exactly right. What happens when you're in a plane with a baby pilot is the same concern you have when you're the first defendant in front of a baby judge who doesn't know as much about how to sentence. And I have only anecdotal sort of evidence of this, but judges that I have talked to have said, yeah, when I was a baby judge, I used the guidelines religiously. I was afraid to go outside of what the guidelines recommended, and it wasn't until I got expertise that I can now, as a much more senior judge, say sometimes the guidelines get it totally wrong.
Right.
And I think it's a question of whether, I'm not sure that that is a net sum better situation than making the judge learn earlier on how to determine what is a right and fair sentence. And that doesn't mean that they're always going to get it right. But they don't always get it right with the guidelines either, if that makes sense.
That's the type 1, type 2 error. And, if I just could push it a little bit, because it would make seemingly maybe a really nice case study to look at Virginia and North Carolina.
Yeah.
Because you just mentioned Virginia as moving towards more of the technology-driven things, and North Carolina backing off. Take two cities that are relatively homogeneous in Virginia and their adjacent states, Virginia and North Carolina, go back, track them over the past 10 years, go forward. I don't know, I was just trying to think of an empirical design to help you make your case. And what outcomes are better and what outcomes are worse. Because I think one thing you're saying is that in a lot of these areas there's harassment. And you see it on campuses. When I first moved here and had Colorado plates on my car, I was pulled over several times. And as soon as they got there, they were, itching to give me a ticket or something, and then they look at me and they say, "You're old."
My bad.
What are you doing here? And I said, "Oh, I just moved here. I'm a professor." "Oh, okay. Can I help you?"
Yeah.
Are you lost?
And I was lost. Where my sons have said, when they get pulled over, they're just hassled. And so part of it is also the I think what you're saying is that these communities that are over-surveyed or biased, that also creates in their mind that the justice system's the enemy, the police are the enemy, and so there's these longer, more deep-seated things that what we're really trying to solve, these kinds of things aren't helping. In fact, they're hurting. And at least that's the way I took the deeper part of your message. Is that right?
Yeah, I think that's part of it. Again, I would just say, I think that you have identified a very interesting sort of empirical question, and one that, that is worthy of exploration. I just think that, there's sort of the question of the things that we can quantify, how can we, and I think you're identifying some of them. There's some very, sort of like there's like a procedural justice literature that says, we can be concerned that, introducing the tools can undermine your sense of sort of justice, including certain factors and things of that nature. I think that's very interesting. I think that literature is not complete, though, because it's not thinking about sort of the overarching sort of concepts or frameworks that we understand what justice is, and that's sort of the question that I'm asking. So I think you're right. Like I recognize that, and it might be worthy of adding a citation or two, because there's definitely that is underlying some of my critique. But I think it is novel in the sense that it's not just sort of the things that we have moved in the direction of trying to quantify. It's also some of the things that are just conceptual.
Right.
So I just want to make a very quick distinction, and I'll be fast about it. Is that okay? Can I take a minute of your time? So I think we're sort of muddying some distinctions that really matter, and it comes back to this question of the narrative, how this narrative operates, because the narrative is actually operating right now, and I just want to point it out. So these systems make it possible to measure outputs, not outcomes. So measuring outputs is like, did the incarceration rate decline? Is it there less racial discrimination?
Right.
Outcomes are like John, who went on probation. How are you? Like, how are you doing? What's going on? And one of the muddying things that we're doing here is collapsing empirical data and quantitative data. Those are actually different things. Ethnography produces empirical data. It just produces qualitative empirical data. So we've basically just erased qualitative data from the room. And that is actually this narrative at work. It's saying the only thing that matters are the things that you can count. And the only thing that is like appropriate scientific study is things that you can count. And that's not true for academic research, right? Like ethnography counts as qualitative data. Like asking people their stories is about like who counts in these systems and how do we make them count. So I just want to be really clear that that we're sort of reproducing that narrative a little bit in this room by saying that empirical and quantitative are the same thing, or by saying that outputs and outcomes are the same thing. And it basically precludes there being room in this conversation for the people who are impacted by these tools, right? Who the empirical data they have to offer is like, how does this feel? Like, what impact did it have on your life? And like, how are you doing now? These are all really important questions that need to be in the room, as well as broader communities that should be able to have the right to say yes or no to these tools, even if they're accurate, even if they're better in quantitatively, because they don't match community values, right? So I just want to make sure that we keep creating space for those conversations to happen.
Yeah, so is this a failure to see how the system actually is, right? Like the people in it, how are they going to use this technocratic thing? Because this is kind of really reminding me of F.A. Hayek's book, The Counter-Revolution of Science, which is part of the Abuse of Reason project that he had, where basically they're going, look, we have a faulty theory, and applying these things, we don't know how it's actually going to get utilized. And in fact, when it's not surprising then that it's deviated greatly from its intended purpose. And so on to that, and unrelated on that, it does seem a lot of the discussion that there's a real knowledge problem here too, right? A lot of the knowledge that we need is spread through time and place, right? On to Hayek as well. And so can the system really overcome that knowledge problem? I mean, you don't have market prices that would do it in, say, a market. And as you've probably correctly pointed out, we don't really want that within the criminal justice system. And so is this kind of solvable, even, because again, what they're trying to do is give us information with these technocratic things, but they're not going to give us the right information at all. And so what's the system that's going to improve it, or is it even improvable, or are we just kind of stuck in a really fraudy knowledge problem?
But so we had this conversation. I'm smiling because we had this at dinner, and I promised not to ask this question. Because I constantly walk around and say, we're doomed. Why are we still doing this? Maybe it's time we stop pretending like math solves everything, and maybe you just need to pay attention and not follow your tom-tom into the lake. So I'll let you have a crack at it, but I will tell you that's a tough question. It's not something that we haven't all talked about, joining forces and taking on these narratives, and the fact that maybe there are certain areas that we need to be careful about math altogether and just embargo its use.
Yeah, so, and actually I want to invite Virginia to respond as well, because we literally were just having, and I don't know that there's an answer to that. I mean, my sense is, like, start really small, and in the context of sentencing, I don't think that these risk assessment tools are actually giving the, correct and appropriate information based on our political values. We're not soliciting information from the communities that are actually affected by the tools, and we're not even soliciting judges and what kind of information they want to know at sentencing, right? It's literally not made for sentencing at all. And I think one of the problems in the context of risk assessment tools and just sort of technologies in criminal justice is that we want it to be one size fits all. We want a risk assessment tool that can be used in parole, that can be used at probation, that can be used in pretrial, and we're not really receptive to the idea that it's possible that in this context at sentencing, we don't need this, right? That we don't need this sort of technological innovation But I want to kick it to Virginia because you had a very different sort of perspective on this, and it's worth sharing.
Yeah, so I don't know if I'm going to hit exactly what you're referring to, but I will tell a story about my experience. So one of the things, this is my 72nd event that's connected to my book, so I've had this conversation a bunch of times. And a lot of them, about a third of them, have been in crowds of data scientists, of people who make these tools. And one of the things that often comes out of that conversation is, like, they really want me to give them a 5-point plan for making better technologies, right? And I have sort of refused to do that. And I'm like, I'm sorry, but I'm not going to do that, and here's why. But one of the things that comes up over and over again is, I will say, I think one of the things that we're failing to do is make sure that the people who are building these tools have the historical and policy context they need to understand, like, what is the history of this policy area? Why might the tool I'm building just, like, further intensify the direction it's been going already? And what kind of levers do I need to install in this tool, to bend it towards justice?
Yeah.
They're not prepared to do that. And I will tell you that I have a very clear memory of talking to a bunch of programmers in a company that does both office software, but also articulates themselves as having a social justice mission. And somebody sitting right in front of me, one of the data scientists sitting right in front of me, heard me give that answer and just rolled their eyes and was like, ugh, that sounds so hard. Right? And so I just think there's something that's so interesting, right, about this moment where, like, all I'm saying is you should know something about CPS if you're building a tool for CPS. And let me give a concrete reason why, right? So in Child Protective Services, there is intentionally an incredibly low bar for proof. Right? So it's not burden of proof. It's like the standard is so low. It's like, I guess maybe something's going on is the standard. And that's intentional in the system because they want to catch everyone that might be at risk. And that's, I think it's a dodgy decision, but it's a decision that got made. But now what's happened is that very low bar of proof has disappeared into this tool as risk, right? Like, so if you think maybe there's a gut feeling that something might be going on, that now is a proxy for risk in these systems. And those are different things.
Yeah.
And you don't know that if you don't know a little bit about the history. If you're assuming, like, oh, well, the caseworker has to have proof that something's going on. No, they don't. Like, they never did. Like, and if you don't know the policy, like, you can't possibly know that speeding up the process of this low burden of proof will create very terrible outcomes for people who are seen as now incredibly risky to their children because that standard of evidence was set intentionally very low. Right? So that feels like part of the solution space is to just say, like, we don't necessarily have the right people in the room. Like, we're not necessarily giving people the information they need to make good decisions around the actual world that we live in. Right? So there's a way we abstract these problems and say, oh, but it would be an interesting thought experiment if this worked. Like, given there was no inequality. And you're like, wait, but there is, right? And that's the world we live in, and we're reproducing it with these tools because we're ignoring the fact that we live in the real world.
Yes.
And that feels very much like what happens over and over again.
Yeah.
So I have 2 comments. One is I read this and I really loved it, but I was a little bit skeptical for 2 reasons. One is you mentioned, over time different states came in and decided they wanted to use this tool, right? So there's this variety over time. And I was wondering if there's any information, or did you other papers to kind of explain, like, how did states become inspired to adopt it? What circumstances were they in that they were like, okay, we really need this tool, we're going to implement it statewide? I think that would really give a lot of credence to how you're motivating this whole thing. I'm not sure there's a paper on that already. The second thing I was wondering is, as I read this, it seemed to me the crux of it was we're trying to understand how the use of this tool might affect how judges sentence. And so I was wondering, are there any experiments, maybe, sorry, to come back to the whole empirical debate, but are there maybe lab experiments that try to understand how a judge would sentence a given a case without the tool and then with the use of the tool and see how different those outcomes would be? And maybe that would really, help us advance the idea that, okay, this is really influencing how judges view the case and how then what the outcome would be.
Okay, so why did states do it? I've actually written a paper on it, and there are a couple of people who have sort of written on why different states do it, and you know, my argument, there are a lot of sort of different cuts on why you think states did it as well, I should say that. My cut is that, you know, at least Virginia was the first state, and it did it like exclusively because they introduced these really severe sentence, budget cuts, and there was this sort of political push to increase punishment severity for different kinds of crimes, and the legislature said, or specifically the policy committee that sort of manages judges and sentencing and collects data on that, said there's no way that we can afford this. We literally cannot afford to implement the sort of policies that the legislature has just passed that are going to increase the length of sentences for so many people. And so they introduced the risk assessment tool as sort of a mechanism to encourage low-level diversion. And, you know, it offset, and this goes, I said this at the beginning, but the argument is that it offset the massive increase in the rating of incarceration in the state. It's interesting that you ask this question, sort of this, again, it's this empirical question, because what I would highlight is we don't have that information and people are doing it anyway. There is a movement now of, like, you know, a couple of more, you know, empirically driven scholars to start assessing risk assessment. I'd say there are two people. There's this woman at George Mason and there's this guy at Duke. And they're the first people really who are saying, you know, it's possible that risk assessment tools aren't working, but it took us about 10 years to ask that question, because we have this idea that it had to improve sentencing because it's introducing more information. And so again, I just want to emphasize this, you know, I see my paper as not undercutting the empirical, sort of empirical questions, but complementing it. And to say that, you know, that's important work, right? To sort of try and show the outputs, but it's not a complete story if we aren't also thinking about the outcomes. And I think that we are very receptive to the empirical literature, and we are very resistant to sort of the humanities-driven critiques. And that says something else about society right now, is that, like, why is it that this is what resonates? And that's something else my paper is trying to beg. You know, we're willing to hear one thing, but we aren't willing to hear both.
So we are out of time. Thank you very, very much. Thank you for the questions. Of course, we can hang out a bit and have some more questions for those of you who I cut off.
Thank you so much for being
here.
here. This is all I know. I'm ready.
I'm just getting cut off.